For my industry expert review, I decided to review a legal podcast on copyright registration and licensing by Gordon P. Firemark, the producer and host of Entertainment Law Update. Firemark has been an entertainment industry lawyer since 1992, providing clients in theater, television, film, and new media with legal counsel and practical advice on how to avoid bad deals, legal liabilities, and be successful in their own businesses. In this presentation, I'll be explaining what a copyright is, who can claim it, what is copyright infringement, if a copyright registration is required before licensing, what options and resources you have if the item isn't copyrighted or you can't find the owner. What is a copyright? The United States Copyright Office, USCO, defines a copyright as a form of protection provided by the nation's law to the author or authors of the published and unpublished original works of authorship. This includes literary, dramatic, musical, and artistic works. This also gives the owner of copyright the right to reproduce the work in copies, prepare derivative works based upon the work, distribute copies of the work to the public by sale, rental, lease, or lending, perform the work publicly in the case of literary, musical, dramatical, and choreographic works. Display the work publicly in the case of literary, musical, dramatic, and choreographic works. Who can claim copyright? Copyright protection starts from the time the item is completely created. In other words, after its creation is finished. Only the creator itself or the parties legally authorized for the rights can claim copyright over an item. For example, in order for a TV show, commercial film, or event company to acquire a license to use the famous Mickey ears, they would have to go through the Walt Disney Company, which is the owner of the rights and has the legal copyright. What is copyright infringement? Copyright infringement is defined as the unauthorized use of work that's protected by a copyright law. For example, if a film requires the use of a song, or depending some cases a piece of that song, they have to acquire a license to use it. Using the song or a piece of the song without legal permission will fall under infringement. A very popular case that was settled out of court was the similarity of the deadmau5 logo and the popular Mickey ears. Is copyright registration required before licensing? Firemark is asked this precise question on his podcast. Since going through the USCO is a time-consuming and expensive process, when needing to clear a piece of music for a TV show or film, is it necessary for that piece to have been registered under copyright or have a copyright certificate to be protected by this law? Firemark said no. Whether the work is registered or not is irrelevant. In this case, the owner has to be tracked down in order for a license to be authorized. What options and resources you have if the item isn't copyrighted or you can't find the owner. The objective is to find who the songwriters, publishers, and or administrators of the song are and explain why you want to acquire a license for this use. This can be done by searching online catalogs of the performing rights organizations like ASCAP, BMI, and SESAC. Use web browsers like Google, YouTube, or any other online resource that might be helpful. Last resort would be to hire an entertainment lawyer to help with the search and licensing process or to choose another piece of music if you can't find the owner. For more information, please feel free to use my references as resources. They have been a big help for me. Thank you.